late.
Say hello real quick.
Judge just told me his courtroom suffers from the same HVAC problems.
Hi, Judge, nice to see you.
Hi, Judge. Yeah, just be careful with the wires.
I see that.
Yeah,
Make yourself
sure.
comfortable, please.
They're here to trip you up.
Good to meet you. Nice to meet you.
Great guy.
Good to meet you. Andy Barnes. Good to meet you.
Well, thank you for coming, sir.
Thank you for having me.
We'll get started. Okay, good afternoon. We just met outside. My name is Mike Sasso. I apologize on behalf of the Fifth District Court of Appeal for the temperature.
That's all right.
But it is what it is. The way we're going to proceed today is that each of the commissioners will introduce themselves to you, and then I will give you 2, 3, 4 minutes, whatever you need to make an opening presentation. We'll then have a period of about 20 minutes, give or take, of Q&A, and then we'll have you have an opportunity to make any closing, finishing remarks.
All right, thank you.
And we have one commissioner who's preparing by phone, and I'll introduce her when we get to her. Go ahead.
Finn Citro with the offices of Horowitz and Citro.
Craig Dyer, Public Defender's Office, 7th Circuit.
Andy Barnes, Gray Robinson.
And Mike Sasso, Sasso and Sasso, PA. I have Commissioner Amanda Perry Carl appearing by speakerphone.
Brett Renton with Shuts, Moen and Orlando.
Good afternoon, Your Honor. Petra Brownlee with the Brownlee Law Firm.
Hi, I'm David DeArmas of Kramer, Price and DeArmas in Orlando.
Your Honor, Scott Thomas with the Byrne Foreman Law Firm. Good to see you.
Performance, James, good to see
Good
you.
to see you again.
Procedure.
All right, thank you. First of all, I appreciate you all having me and taking this time out of your schedules. I know how busy you all are. And also want to thank you for reading, I can see a stack of volumes over here that you have. I attempted with this application, and I know mine wasn't necessarily short.
Thank you.
But yeah.
Thank you.
I attempted to keep it shorter than I've done in some of my past ones when I applied for the 7th Circuit, and I included a 120-page law review article, but in any regard, unfortunately, short has not always been my strong suit, and as you can see, I think from maybe the 2 opinions that I've listed in there, one was short, the other one was a long family law order. I think it's an obligation of the judge to explain what they're doing and fully explain why they're doing what they're doing when they present an opinion or an order to the public. And in the same way I approached it with your application. I think I'm a fairly transparent person. I don't think I'm terribly complex. What you see is largely what you get with me. I have had a lot of experiences in my life, and I would hope to take those to the next level. I would describe myself probably as a law nerd. I love the law, I love practicing law, but I really have a deep and personal attachment to the rule of law. And I'll explain a little bit of that maybe towards the end. But that comes from the experiences that I've had traveling on behalf of our country internationally and dealing with lawyers and with other legal systems as well. And obviously, although we don't deal with international law here in Florida most of the time, it has given me an interesting perspective that I would hope to take up to the 5th DCA. I love, in my current practice as being a trial court judge, I love motion practice because that is an active, engaged opportunity to talk to smart, young, and experienced lawyers and to understand what it is they're arguing about the case and to allow them to fully inform me of what it is that they're about in the case, and then to have an open discussion so that they understand where I'm coming from and give them a chance to ask all the questions that they have to explore with me where I might be going in the case. And I think that's the same kind of skill I would bring to the 5th DCA. As I said, I've not written a lot of short orders. Most of mine tend to be a bit long, and they aren't necessarily quick. And I will admit that's a shortcoming. Of course, as a trial judge, even though we have staff attorneys, we have, in Putnam County, we have 1 that we share among 5 of us. St. Johns County, we had 2 that we shared among 6 of us, and in both cases, the 3.850 motions took up most of the staff attorney's time, so didn't get to use them a lot. So I'm very, very interested in explaining to the parties what happened. When they leave my courtroom, or at least when they read my order, I'm hoping that they understand that they had a chance, they had a shot, that I tried to understand their case as best I could, that I tried to understand the law as it is and apply it to their case. And with that, I look forward to taking your questions.
McGillin, as you know, I had the honor of vetting your application. And so
I heard from a few people that you had called.
first and foremost, thank you for your service.
I appreciate that. Thank
Not
you.
just to the state of Florida, but to the United States. I know that the positions you were in can change from time to time based on the TJAG and administration. So my first question is, in the work that you did once you achieved the rank of lieutenant colonel and up, how much of it was the practice of law versus administration and policy?
I was actually fortunate in a couple of the jobs that I had. My primary duties as a lieutenant colonel were as the staff judge advocate and deputy staff judge advocate of an installation. And in that case, I was the primary legal advisor. As a staff judge advocate, I was the primary legal advisor to the commanding general. Whoever he or she was, I was their lawyer, their general counsel, think of it in those terms. Simultaneously, I had to run a legal office of anywhere from 20 to 40 attorneys while doing that. So it was probably about 50-50 with practice and management. In my last two positions, I was a full colonel, and I got promoted to full colonel and got sent to the Pentagon actually just 9 months after 9/11. So I saw it while it was being reconstructed. And I was the general counsel, executive officer, and special counsel to the general counsel of the Army, who's a Senate-appointed, Senate-confirmed presidential appointee, senior legal beagle in the Army. He's the top lawyer. He actually outranks the TJ because he's a civilian, and we have civilian control of the military. For that year, administrative with some special projects. And then for my last 2 years, I was really back to practicing law again. As the legal advisor to the Army Inspector General, who's a 3-star general, my job was to assist him and the staff, the entire staff of the Department of the Army IG in reviewing all the inspections and investigations that they did Army-wide. And they ranged from going to a base and finding out what the equal opportunity climate was on the base. In that case, I'd be applying civilian personnel law and military equal opportunity law to investigating general officers. The Inspector General of the Army is the only one authorized to investigate misconduct by a general officer. So we would work closely with the investigators, developing the investigation plan, the questions that they were going to ask, and then when the investigation was over, I had to provide legal advice to the IG in terms of whether he should approve it from a legal standpoint. There was an interesting thing that happened in that role. A defense counsel that might be representing one of those generals is not entitled to see the entire file. It's just the way the Inspector General regulations are written. I know you were in federal practice, Mr. Citro, so you're aware of this. They don't get to see the whole file. The last lawyer that sees the whole file unredacted was me. And so while I wasn't leaning or working for the defense side, I knew I had a special obligation, kind of like a judge, to give a fair legal read with access to all the evidence and give that advice to the Inspector General. There's quite a few times that we would say, you know, it's not quite ready yet. This is not quite good enough yet. And we go back with the investigators, work with them, and get it perfected. About a year after I retired, I got called by the Department of Defense Inspector General. They were doing an investigation of our investigation on a case a year before. And I can't talk about that case still. Let's just say it was a highly classified, high-profile fratricide case. Probably guess who or what it was about. But he said, well, we got a copy of one of your draft opinions, and you said this in the draft opinion that you disagreed with this, this, and this. Why did you change it between the draft and the final opinion? And I said, did you read the word draft? At the time. It was truly a draft. We were helping develop the investigation and work with the investigators and say, no, you don't have. And at the time, they didn't have enough evidence. And we went back and said, when my boss said, it's not ready for prime time. Went back, the investigators did more work, came back, and it was fine. Now, we got investigated a year later, but that's okay. I stuck with my recommendations. I'm still trying to figure out how they got a copy of the draft. So,
I was gonna ask you that.
yeah, technically the draft it's not subject to FOIA or release because it would have been essentially work product. It probably was still on my computer.
Yeah.
So, but that's okay. It was a draft and it showed where we were in the investigation at that time. I try to be careful now about my drafts. My JA and I are the only ones that get to see those now.
I had such a fun conversation with Lieutenant General
Michael Shea.
Yeah, we had just a blast on the phone, and he and all the way down to the remainder of your references spoke glowingly about your legal acumen, your tenacity, and how hard you work to get things done right. As as hard as I tried, there were only two concerns I could find in the references, and the people whose references led me to other references. That was one, the length of time the issue to address that. The other was people made it very clear that you are passionate about the Veterans Court and the Veterans Program and how you do that. And while many of them wanted to tube your chances at this, their only concern was how you're going to come here and miss that, or ensure that that continues, or that you get that, for lack of a better analogy, itch scratched by continuing that passionate work that you've done over the course of your career.
No, I appreciate that. The Veterans Court was a special project that I helped get started in St. Johns County. We've been working on it before I got to the Seventh Circuit bench. I already had one of the other judges lined up to be the Veterans Court judge. Judge Tinlin was going to be our Veterans Court judge, and then the governor gave me that call that day in November, and about a few days later I saw Judge Tinlin. He said, "So you're going to be the Veterans Court judge now?" I probably am. So that has been a true labor of love. It is a lot of work, but the reality is, this comes out of my military background. You're always training your replacement. That was one of the things one of my bosses told me. You're always training your replacement. And I've taken that to every job that I've been in. And so in this case, if I get the privilege of coming up here and working, I have to make sure I've trained my replacement. And there's actually a couple of the judges in St. John's that have done Veterans Court when I've been away. A couple times we've talked about it, I mentored them. In fact, the guy that took over my division had to handle it on an emergency basis one day because I had a criminal trial that ran a day longer than we expected. And I had a jury literally out in the jury room deliberating, and I was coming up on when I had to drive to St. Johns County to go handle Veterans Court. I called Judge Renzio, gave him the quick brief on the phone, and he took over. The key thing there is, and Veterans Court is a good one, is the team. Absolutely, the team is the key to that one. And we have a great team, and it has evolved. There's only 2 of us now that are on that team that were on it when it started 3 years ago, and went to Buffalo and saw the first Veterans. But that's the key, is train your replacement. And I do that in every aspect. I did it when I started the Lunch and Learn program with the lawyers when I went on the bench, because I think I'm training my replacement, not just my replacement on the bench, but my replacement on the bar as a litigator. So I think that's a critical thing that everybody's got to keep in mind as they go through this.
That came through, especially with the younger lawyers that you mentored. Thank you, that's all I have.
Your Honor, first, if I could abuse my time a little bit and just take a moment to thank you for the time you give to the new men of court in St. Johns County, St. Augustine, that you and the other judges do. That is really crucial to that being successful. And
We're hoping to have a really good year this year.
yeah, I hope so. We really appreciate that. If I got the timeline right, you actually applied for the 5th DCA back in 2012 when
I did.
still in private practice.
Actually, when Judge Berger got that appointment was the time I applied. I did.
We've had several openings since then. I'm just curious, why no application till?
Well, when I went back after that happened, I did apply for the 7th Circuit and got great feedback from that application. So at that point, I kind of turned my focus to let's hone my skills specifically in the trial court. I realized when I made that application early on, I was really fresh out of the Army at that point, quite frankly. And I had not spent a great amount of time practicing Florida law. I brought all those wonderful experiences from the Army that I truly think are wonderful, but I hadn't had a lot of experience in Florida law. So I then focused on the trial courts, and I applied. Each time I applied with the 7th Circuit, I was nominated, got to go up and competed at the governor's office, and each time was beaten out by a better judge. Particularly the last couple times when I went up, when Judge Don Nichols got appointed, and then Judge Dave Hood, rest his soul, got appointed. You know, those announcements came out, and I said, good job, go back to practicing law, and then wait for the next application. And then I was encouraged to apply again, and I did. I think those times have been important to develop, you know, who I am, both as a lawyer and as a judge, more important. And so when this opportunity came up, when I saw this application, I thought the time was right. In addition, I had waited, quite honestly, I had waited until I had spent a number of years. I'd spent primarily time as a family law judge, but we're a truly unified family court in St. Johns County. If you want to see what unified family court means, come to St. Johns County. It is everything that the family touches, including foreclosures. So I wanted to have that broad experience, and then when the opportunity came up to go on the criminal bench, I wanted to have that in my kit bag as well, because quite honestly, this level, a lot of their work is criminal. I know because I look at my current list of cases. And in 6 months on the criminal bench, I think I've already got more filed for appeal than I did on the family law bench. And that's because every appellant, everybody that is convicted is entitled to that appeal. And, you know, if it's your last shot, I would take it too. So,
I can't remember the exact statistic, but the disparity between the number of criminal appeals the Fifth DCA hears versus the opinions that are issued, criminal versus civil, is a very large breakdown. But my four commissioners have heard some version of this from me already today, but there's slightly different skill set between being a trial judge and a appellate judge. What is it that attracts you, or what is it, why would you want to make this transition from a trial bench to the appellate bench?
I mentioned in response to Mr. Citro's question that you always train your people that replace you. I think that the appeals court has an important role. First off, a sorting role, quite frankly. Sorting to a certain extent because there's so few cases that really go up from here to the Florida Supreme Court based on their jurisdiction. It has both a sorting role in sorting out the cases that really need to be heard, and also I think it does have an important educational role. And that may have not been emphasized as much here lately. So I probably would write a little more than has been seen necessarily coming out here, because I think that the parties deserve to be told more than just no. Now, sometimes, and this, I came up here as an associate judge last year, and so I've heard the kind of the scuttlebutt. If you write anything, it's appealable. And so there's a legitimate concern that you're opening up the door and creating more caseload work for the higher level courts. But the reality is we're here to serve the people. And somebody that comes to this court, this is, for most, this is the last stop. Very few cases are going to go up to the U.S. Supreme Court or the Florida Supreme Court. This is the last stop. And if they get told no, if the trial judge did a good job, which I hope I've tried to do in writing an order that explains why the answer is no, then the appeals court should say PCA. If there hasn't been a clear explanation, I think this court has an important obligation to take up the factual findings that the trial court's made, reiterate what the law is, or explain what the law is if it's not entirely clear. And I've already found in 6 months on the criminal bench, a lot of places where it's not entirely clear. So there's a lot more development to be done. That's the long answer to your short question.
Judge, what's the longest that it's taken you to write an order?
I probably had one that was almost 6 months. And if I took 6 months to write it, it probably was in the 30 to 40 page long length. And the reason for that, particularly in family law cases, there's a lot of findings of fact that you're required to make. And I take that to heart. That's my job. In fact, I also know that if I make a finding of fact, they're very unlikely to overturn it up here. But more importantly, again, to tell the people what it was about their case, particularly in family law, that made a difference. The emotions are so high in those cases. It's important to have somebody that looks at it objectively and rationally and explains, you know, no, it's not this reason, it's this, this, and this reason. So that's why it took so long. And then I would get a snowball effect, and that was the problem. So I will tell you, as soon as I went onto the criminal bench, that backlog was cleared up within about a month or two, and that was just using spare time. My first month, actually first 2 months on the criminal bench, trial docket weeks entirely washed at the very last minute, so there was very little ability to put in time. That time I used, slammed it, got the rest of the orders done. Still have one family law case out of St. Johns County that I'm still the judge on because it's back on the second rehearing because there's been some additional drama that has evolved in that case. So that one's going to take a while, and that was a long order also. That's why.
Yeah.
I mean, another boss in the Army, I live by these wonderful expressions, but this guy said, if you want it real bad, that's just how you might get it. So,
That took me a second, but I got you.
yeah, it's better to probably get it right than get it fast. Now, I can do fast when I need to. I had a case where the wife in this case was a French national who was on the cusp of being deported. If she did not leave actually not necessarily deported, but she would be in an undocumented illegal status. And so we had the trial, we got the trial done as quickly as we could, got it on the docket, and I got my order, the trial order out in that case, put everything else aside and got that one out in about 48, 72 hours, and it was a long one. It took a lot of work, and I'm not patting myself on the back. Weekends and evenings is fine. My wife's used to that after all those years in the Army. But we got it done. We got it done in time so that she could leave the country with a court order and not be subject, in her case, to a bar on reentry, which would have really messed up the time-sharing plan. So I can do it fast when I need to. I would prefer to be deliberate and get it right.
And to be clear, I know there's not very much time for you circuit judges to write. I know you have very busy dockets, so we appreciate that.
Thank you.
Is there a particularly complex or novel legal issue, apart from complex facts, just pure complex legal issue that has come before you that maybe you were not familiar with at the time? And if so, how did you go about trying to untangle that and resolve that issue?
There is, and I mentioned it in the application. There was one case, and I'll just give you a synopsis of the law. We were at a unified family court in St. Johns County, and I was sitting as a dependency judge. And under Chapter 39 and Chapter 63, the adoption is the Chapter 63, 39 is dependency. There's a procedure whereby somebody who's facing a termination of parental rights can have someone that they want to elect as the adoptive parents for the child. And the legislature had guidelines in Chapter 63 that essentially said the trial judge has to do this, then this, and this. And interestingly enough, one of the other judges you're going to talk to today, or tomorrow, I think, Judge Strobridge, was one of the attorneys that helped craft the version of the statute, and I actually consulted with her on this particular case. The original version of the statute said you do not compare the prospective adoptive parent that the Department of Children and Families has with the one that the family has put forward. And under the existing law, as it existed when the statute was first written, there was no comparison. There's case law that says no comparison. About 3 years ago, the legislature went back and amended that statute. And I had this case in front of me with that issue presented right after the amendment went into effect. And so I was really one of the first ones in Florida to take a look at it. I don't know if I got it right. It did get up. Nothing got overturned up here. I'll just put it that way. But it was very complex because even though the language of the statute didn't say you're to do a comparison, it required you to consider certain other factors, including the current placement of the child. And so it may sound simple, but I had to kind of wrap my brain around why the legislature made this particular change, and I concluded that in the order that they must have meant for there to be a comparison. They didn't use the word comparison, which they had. They didn't use it, but when they say I must consider that, how can I consider it without it being in some way a comparison between the two placements? And so I made that decision and wrote up the order. And wow, you want to talk about, those are the toughest cases. People say criminal cases are the hard ones. No, when you're dealing with a child's future, that's the hard case. That's the real tough one. But good question.
When a statute is not clear, it sounds like maybe that statute wasn't at least crystal clear. How do you interpret that? What sources do you look to? What do you consider in order to try to ascertain its meaning?
The first best thing is to read the text of the statute very, very carefully. To include placement, believe it or not, of the commas. I had a case recently in front of me on the criminal bench involving, I think it was file on felony offender of special concern. Mr. Dyer will be familiar with that issue. But there was, I kept reading the statute and I said, gee, I don't think this applies in this case. And the state attorney said, look at where the placement of the comma is. And I had read it carefully enough. And that's why I love that discussion with the smart lawyers. And I was persuaded that it meant something different. So obviously you start there. If it's not clear, then you have to go to the rest of the statutory construction. You try to understand what was the reason. In the case of this one that I did, the one with the adoption, I did go back and look at the legislative history specifically to try to find out why the legislature, or at least why their staff that was preparing the report for them, said they thought they were making that change. And to understand that. And I read it, and I went back and I read the case that actually Judge Strobridge had been involved in, and tried to understand why they were making that change. And that was part of what led me to believe that the change in the language had significance. If they had wanted to leave it as no comparison, why would they add considering this other factor? So That's a key to it. Of course, you always end up with the issue of, you know, you don't want a ridiculous result. I've listened to a couple of oral arguments recently. I told you I'm a law geek. I have a 33-minute commute from Putnam County to my home in St. Johns County. And it's just about the length of an oral argument at the Supreme Court. And you can listen to it when you're driving in your car now. So I've listened to a number of those recently, and very interesting to hear exactly those kinds of issues being discussed. And I just, you know, I'd rather listen to that than listen to music. I like to play music, but that's just the way I am. So very interesting to hear those discussions.
Let's just say I was to pull all of the opinions that have come out, all of your opinions that have been appealed,
Okay.
and taken a look at them. What do you believe should be the conclusion drawn by looking at those opinions?
Since all but one of them are a PCA,
Right.
I would hope that the conclusion you would draw was that the appeals court said exactly what I said I hope to do up here, which is, in this particular case, the trial judge did their homework. My opinions generally have a structure where I'll say procedural posture, the law that applies, and then my findings of fact or findings of conclusion in law. So I try to do an analysis procedurally where we are and why that might matter. The law that applies, I try to lay it out really clearly. This statute, this case, and here's where I think I'm headed. And then do the analysis as required under the findings of fact and conclusions of law. And I think by the time you get to the end of that, I would hope that the appeals courts have looked at all of them and said, you got it right. Now, the one they wrote an opinion on, I got it right. I got the facts right, I got the law right, I even made an oral declaration of the findings correctly. And then I asked the attorney to draft the opinion for me, or draft the order
I
for
was
me.
curious how that.
And the attorney drafted the order, and the attorney for the winning party conveniently left out that in that case it was a psychiatric report, was supposed to be kept close hold to attorneys only. And I had orally pronounced that. It came out in the order, I read the order, and I just missed it. Just plain mistake. And that's the other reason why these folks are here. We're human, we make mistakes. And so that order came back and said, yeah, McGillin, you got the law and the facts right, you just didn't write down exactly what you said. So we fixed that. In fact, I talked to one of the attorneys later on, I said, why didn't you come back on a motion for reconsideration? Quite frankly, they were at the end of they had to file the appeal to keep the door open. She told me later on, we would have been back, and I said, I would have fixed it in a heartbeat. And I've done quite a few of those. I have turned 180s on a reconsideration because the parties came back and argued something new that I had not heard, and it was usually on a legal analysis of the factual impact on something. And I've done it 180, not often, but I have done that when I've had to. I'm not afraid to say when I get it wrong.
How would you describe your judicial philosophy?
Well, I wear the black robe like I'm supposed to. That is always the toughest question. It's laid out in my application there. That is that I follow the tenets of West Point, quite frankly, duty, honor, and country. As a judge, it's my job, my duty to follow the law. There are times when I'm making a decision that I don't necessarily like the decision I have to make, but I'm going to follow the law. I'm going to do my job. When you swear to uphold and defend the Constitution, particularly when you do it in the military, you're writing that proverbial blank check that you're going to do everything up to and including, posting your life as collateral. I understand duty. I understand that very strongly. It's my job to follow the law. There's a bunch of fine folks in Tallahassee and Washington, D.C. and in our local city councils that get to make the law. My job is to figure out what it is they said when they wrote it down, because they don't always write it down clearly, as we already talked about, and then apply that to the particular facts in front of me. I'm not in the judicial activism role. There are aspects of law I don't like. I wish I could reinterpret them, but I'm not going to, because that's not my job. One of the aspects has to do with concealed carry permits, by the way. I have one, and there's places I can't take one as a judge, because I'm a regular concealed carry permit holder. And the law says that law enforcement officers can go take them to another place. And I could twist the law around and say, because I have power of arrest as a judge, that I'm a law enforcement officer, and therefore I can do those things. Well, I'd love to reinterpret it that way, but no. So I don't carry my concealed weapon inside a school. Not a good idea.
Okay, well, thank you, Judge. That concludes the Q&A portion. I'd like to give you an opportunity to say a few closing remarks.
All right, thank you. First of all, we really appreciate the time, and I've enjoyed discussing these issues with you. I mentioned up front that I'm fairly transparent. I'm not really complex. I mentioned the beauty honor country motto of West Point. You know, a lot of people like to say that our Constitution, and in particular our Constitution, is a skeleton or a framework. Other people say it's a partially completed building, things like that. I'm going to use a different analogy, and I think it's important to talk about. It's like our DNA of our society. Now, between those of us that are here, if you've been through the DNA analysis of a criminal trial, you'd hear this. We all share about 98% of the same DNA because we've all got 2 arms, 2 legs, 10 fingers and toes, things of that nature. You look across the world, and this is the opportunity I've had in the military. There's a lot of constitutions out there, and a lot of them say the exact same things that ours does. In fact, I bet, I've never read it, I'm not really interested in reading it, but I bet if you read the Constitution of the Democratic People's Republic of Korea, North Korea, that it talks about freedom and opportunity and all these great things that government's going to do, and yet we know that that is meaningless in a dictatorial society. The difference between just having the DNA, the Constitution, and having a country like ours, which really is truly the greatest country on the face of the earth, and I've seen a lot of them, is the people that operate and carry into effect our laws. You've got to have people that care. You've got to have people that love the rule of law. You've got to have people that are dedicated to it and are willing to take that oath and take that oath seriously. My last year in the Army, I got to visit the former Yugoslav Republic of Bosnia-Herzegovina. And if you want to see a place in this world that will tear your heart out about the failure of the rule of law, go to Bosnia. I've got a picture on my iPad. I'm not going to show it to you, but I pulled it up just to remind myself today of why I'm here and why I do what I do. And it's a legal office in Srebrenica. If you look at the picture, it's a temporary legal office because it's just a banner hanging out of the window, but there's a Scales of Justice and Law Office written on there in English, not actually in Bosnian, right next to all the bullet holes and shell marks in the building. That's what happens when the rule of law fails. We can't let that happen in America. And the bulwark against that is not just our Constitution, our DNA, it's the people that place that into effect. And I hope I've done a decent job at that. And quite honestly, if I keep on doing it at the trial level, that's a wonderful thing. I'm in contact with people every day, and I love that. But I think I've got a little more to offer, and I would look at the opportunity to carry that to the next level. So I want to thank you very much for your time. I really appreciate it, and hopefully the air conditioning will start working again soon. All right.
Thank you
Thank
so
you.
much
Thank you very
for
much.
coming.
Take care of yourself.
And thank you very much for your service.
Yes, thank you for your service.
Appreciate your support.
Thank you. Of the 3 doors, it's the one on the extreme right.
No, thank you very
Not
much.
the extreme